Hello. Well, as Ben said, I'm going to be looking at Article 6 and Article 8 and how they impact on the sort of issues that employment lawyers are required to grapple with all the time. For each article, I'm going to start by looking at the article itself, then a brief look at how the European Court of Human Rights has interpreted or applied that article before moving on to the domestic context. So starting with Article 6, the right to a fair trial, I haven't put the whole thing up, I've just put the important bit at the start up. In the determination of his civil rights and obligations or of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. And I think the important bits, or the difficult bits perhaps, of that are what is meant by the determination of civil rights and obligations and what's meant by an independent and impartial tribunal in the employment context. There are two very important ECHR cases that look at this. The first is, I have a terrible accent, so Lecomte, but it's probably not Lecomte, which looked at a doctor who had been suspended as a result of disciplinary proceedings, so suspended but not struck off. But the ECHR said, yes, that is an interference with your right to practice as a doctor. The other was Werner and Poland, again it could be Werner, who knows, where the ECHR considered the applicability of Article 6 when considering someone's professional reputation. This person was a lawyer and also a judicial liquidator of a company, and he was dismissed after complaints that he wasn't trustworthy. He challenged his dismissal on the basis that his good reputation as a lawyer had been damaged by his dismissal. And the ECHR agreed with him and said the right to enjoy a good reputation, to have it determined before a tribunal, the justification of attacks on such a reputation is a civil right, but within the meaning of Article 6. So therefore the view from the ECHR is your right to practice your profession and the determination of your professional reputation. So how does this translate? Well, Ben's already looked at in some detail how this translates into the employment tribunals. But of course, it's also worth remembering that you've also got the overriding objective before employment tribunals, particularly Bash and Essex County Council, where Lord Justice Mummery said, well, the employment tribunal has to be fair to both sides. The employment tribunal is responsible for the conduct of a hearing. As I once heard an employment judge remind a different advocate, not me, it's my party, not yours. But at the same time, all of those involved are required to act fairly. And of course, the usual, I don't think anyone would suggest, although of course there have been cases on the detail of this, that in most cases, an employment judge, with or without wing members, will represent an independent and impartial tribunal. Much more complicated is the issue of internal disciplinaries, dismissals by public sector employers, particularly the sort of dismissals that are likely to bring the employee's career to an end. The initial leading case of this was one of John's cases, called Carney and Milton Keynes, where he was leading Jonathan Davies, also of these chambers. This was a junior doctor still in training who was facing allegations that he'd conducted an improper patient examination, and he wanted legal representation at his subsequent disciplinary proceedings. Now, the Court of Appeal decided that actually he did have a contractual right to that by reading over various provisions from the standard capability contract into the conduct part of that contract. But for this talk, the important bit was that Lady Justice Smith also said, well, actually, if in ordinary internal disciplinary proceedings, if you're just looking at the dismissal of someone's job, that doesn't engage Article 6, but where the impact is actually going to destroy someone's or deprive someone of their career, then Article 6 is engaged. And she said, particularly in this case, the NHS was a monopoly employer. In Dr. Kulkarni's case, if he wanted to finish his training, that was going to have to be with the NHS, and therefore, if he couldn't get an NHS job, he couldn't train as a doctor, and also that it looked like a system of alert letters was going to be sent out about him, warning trusts not to employ him. So then the question then came up was, how far do you take this? And there were a number of unsuccessful cases. Dr. Hamid, who was a staff grade, so one below consultant, who'd not sterilised something and then lied about it and was dismissed. And Mrs. Justice Swift, sorry, I've said Smith in the handout, but it was Swift, said, well, actually, no, Article 6 not engage on these facts. Leaving sterilised scissors somewhere or not sterilising them is completely different from effectively a sexual assault on a patient. She's got a good reputation in the NHS. She's worked for many years without incident. She'll be able to get references. And therefore, this is not a career-ending dismissal. And I think we've heard anecdotally for her, it wasn't a happily for her, it wasn't in the end a career-ending dismissal. I don't know what's happened to Dr. Kulkarni. Mr. Puri was a urologist. He, again, was slightly different. He was dismissed following allegations of rude and improper patient behaviour towards patients. He could still practice privately, but not in the NHS. And he said his NHS practice was of a much more advanced and specialist nature than his private practice. And we argued there a partial cessation of his right to practice failed dramatically. Mr. Justice Blair said, absolutely not, this is completely different from Dr. Kulkarni. He wouldn't be able to complete his training. And Article 6 wasn't engaged on these facts, probably quite weak facts in some ways. Then came Matu, which is another John case. Dr. Matu had been dismissed following a hearing that in effect he was unmanageable. It was quite a sad story. He'd whistle-blown 10 years earlier, had been suspended for almost 10 years on what turned out to be trumped-up charges, and then was trying to come back to practice in the NHS, not particularly successfully. I say trumped-up charges. He was facing dismissal, but actually he was given what was replaced with, after a long inquiry, a six-month warning. He was then facing dismissal and was dismissed. And Dr. Matu argued that the effect of his dismissal was determined of his civil right to practice. He hadn't worked for nearly a decade. He obviously required significant reskilling in reality before he returned to safe clinical practice. Only the NHS could provide this. And when that's coupled with his need to spend... when you coupled this with a finding of gross misconduct against him, was he realistically ever going to work again? The Court of Appeal approached it differently from Mr. Justice Blair. They said, well, actually, the application of Article 6 simply can't be fact-dependent. It can't depend on whether or not the doctor is likely to obtain work again. They said Article 6 is engaged with legal rights and obligations. It can't, therefore, vary on the facts of the case. Lord Justice Elias, went further and said, well, actually, when you dismiss someone, you're exercising your right to dismiss, albeit restricted by contractual disciplinary processes if there are some, and therefore an employer is asserting a right to dismiss, not determining it one. Hence, there can be no determination of your civil right to practice. And went on to, and Stanley Burton went on to doubt the words of Lady Justice Smith in Kulkarni. However, what they did say, importantly, was, but if Article 6 had been engaged, a hearing by the Chief Exec wouldn't have been Article 6 compliant, even though he hadn't had any previous involvement in the case. I should say that that's very different. This is very different from Dr. Matu's recent employment tribunal claim. Dr. Matu was refused permission to go to the Supreme Court. However, it is one of the cases that John mentioned earlier that's going to the ECHR. And encouragingly, since it was handed down, or encouragingly for those of us on the doctor side of this case, is the ECHR case of Volkov and Ukraine. Volkov and Ukraine looks at both the applicability of Article 6 and Article 8. Importantly, for these purposes, it looked at the dismissal of a judge, and it held that a dismissal of the judge did engage Article 6, and on the facts of that case, he hadn't been given the benefit of an independent and impartial tribunal. They also went on to find that the dismissal constituted interference with his right to respect for his private life, that the dismissal wasn't lawful in accordance with domestic law. He'd been charged with breach of oath. There was no such thing. There were no procedural safeguards in place and no scale of sanctions for disciplinary offences, and there was also a violation of Article 8. I should say Matu is being argued on the basis of Article 6 and Article 8. Sticking very briefly with medical professionals, RG versus Governors of X School. This was another not particularly nice case where a teaching assistant in a primary school was accused of sexual relations with a 15-year-old work experience student. He argued not that his dismissal proceedings himself would determine his civil rights, but they would have an impact on later proceedings that would determine his later safeguarding proceedings that would determine his civil rights. The Supreme Court said, well, yes and no. Yes, if that was really the case, if an internal disciplinary is really truly dispositive of later proceedings or is going to irreversibly prejudice them, yes, it is determinant of your civil rights, but not on these facts. But what Lord Brown did say in that was, and I think it does go without saying, as I need hardly observe, each of them is an independent, in looking at the regulatory proceedings, so the General Medical Council, now Medical Practitioners Tribunal Service, the NMC, the GDC, Article 6 really is engaged, and that must be right, because these bodies have the power to strike off and suspend medical and other health practitioners. And just to see how important that can be, but also the limits of it. In Priest and General Dental Council, a suspension for 12 months did engage Article 6, but a warning, as you can see from those cases, did not. But an example of how important it can be is on the application of Bonhoeffer. This was a man who was accused, I think it's of sexually assaulting or sexually abusing others. And he was accused of assaulting X, who'd also said that he'd assaulted some other people. The other people said, actually, that's not right, but X maintained his position and wanted to come and give evidence. But there was concerns about the risks to X if he gave evidence. And the fitness to practice, I think it was probably still the GMC back then, wanted to go ahead with the hearing based purely on hearsay evidence. This was unsurprisingly judicially reviewed, and it was found that on the facts of this case, no reasonable panel could possibly have concluded that the factors outweighing bringing this witness over, who was very willing to come over, could possibly outweigh the need for a fair trial and proper examination of the evidence and cross-examination for this particular doctor. And in your handout, Mr. Justice Stadlen set out, I won't go through them now because we're so low on time, but he said, well, the right to cross-examine isn't an absolute right, but these are the factors you should take into account. But clearly on those facts where someone's facing fairly horrific allegations and a witness is willing to testify, the court found that absolutely they should be required to testify, and that evidence should be properly tested under cross-examination. Article 8, the right for private and family life, just anyone up there with small children. Everyone has the right to respect for his private and family life, his home and his correspondence. Furthermore, there should be no interference by a public authority with the exercise of this right, except such as in accordance with the law and is necessary in a democratic society in the interest of national security, public safety, or the economic well-being of the country, etc. So you've got a right to it. It shouldn't be interfered with, save if it's in accordance with law and there's some, in effect, justification for it. So first of all, looking at pre-employment checks, is Article 8 even engaged? We're talking about work here. Does work really engage one's private life when most people want to keep the two separate? Yes, says the Supreme Court. Per Lord Hope, this is in your handout, it has been recognised that respect for private life comprises to a certain degree the right to establish and develop relationships with other human beings. Excluding a person from employment in her chosen field is liable to affect her ability to develop relationships with others, and the problems this creates as regards the possibility of earning a living can have serious repercussions on the enjoyment of her private life. So that's obviously a very important statement of actually the importance of work in people's private lives. So the next bit, what does in accordance with law mean? Again, the ECHR has looked at this. In accordance with law means the law must give the individual adequate protection against arbitrary interference. There's been a very recent Supreme Court decision, RT and another versus Secretary of State for Home Department. I hadn't noticed when I wrote this, but it is now reported on in the weekly law reports, 2014, 3 weekly law reports, page 96. This concerned the application of the Rehabilitation of Offenders Act. As I'm sure everyone's aware, convictions become most convictions, but not all, become spent after a certain period of time, and subject to a very small exception, cautions are spent the day they're given. And this is obviously very important for people wanting to move on from past misdemeanours and obtain employment. But there are exceptions. Enhanced Criminal Record Bureau checks, now covered by the Disclosure and Barring Service. So under the old legislation, it's now changed. If you were looking at enhanced, if you needed an enhanced CRB or DBS check, actually everything would come up, including your spent convictions and your cautions. And for two individuals here, this had quite an extreme impact. The first was T, who, aged 11, got 2 warnings for stealing bicycles. Obviously spent, aged 18, applied to do some sort of sports degree at university, and was rejected because he would have to work with children on that degree, and he obviously failed his enhanced CRB check. Another was a woman aged 41. She had a caution for stealing a small item from a chemist. 9 years later, having undergone training, she tried to get work as a care assistant, and she was rejected on the basis that due to this caution, she was unsuitable to work with vulnerable adults. The majority of the Supreme Court said this is not in accordance with law, and more importantly, they all found that it's not necessary in a democratic society. Necessary to accomplish the statutory objective, it was not, because it failed to strike a fair balance between their rights and the rights of the community, and so violated their rights under Article 8. As Lord Reid said, I cannot see any rational connection between minors' dishonesty as a child and the question of whether, as an adult, the person might pose a threat to the safety of children with whom he came into contact. Now, this has, and I put it in the note, been to a certain extent resolved now by various statutory instruments that talk about protected cautions that, in effect, if you're under 18, they're spent within 2 years, over 18 within 6, and also some protected convictions. So to a certain extent, that's old law, but it does show the extent to which the Supreme Court's prepared to interfere in this area. Leach and Ofcom was the case that Ben mentioned at the start, with the rather dismissive words of Lord Justice Mummery. That was a case where an employer had received information from the police that someone might be a risk to children and might have done some nasty things with children. He said that dismissal's not fair. He hadn't been convicted of anything at that stage. But as a slightly terse comment in the Court of Appeal, any worries about injustice when his dismissal was upheld at ET and EAT and Court of Appeal level went out of the way, because he couldn't actually attend his Court of Appeal hearing because he was in a Cambodian jail by that point for abusing children. Covert surveillance of employees. The view from the ECHR, again, they say, well, actually, you do have a private life at work. Interference with your telephone, email and internet usage at work can amount to a violation of your Article 8 rights. And similarly, but there are limits. In Kopeck versus Germany, an employer realised that money was being stolen from their tills. They put some cameras in place, but they said that was actually justified on the facts. Very briefly, looking at the domestic context, just to be aware of 3 pieces of legislation. The Regulation of Investigatory Powers Act, I've put it in more detail in the handout. Part 2, which is the generic one, has been held by the Investigatory Powers Tribunal not to apply in the employment context. Part 1 would apply, except that the Telecommunications Lawful Businesses Practices regs actually say that interceptions will in effect be permitted in order to establish the existence of facts, to ensure compliance with standards, for assistance security, for training, and to prevent and detect crime, i.e. it's allowed. Data Protection Act, similarly, there's guidance by the Data Protection in the Data Protection Code, but it all in effect comes down to reasonable expectations of privacy. Does your employee have a reasonable expectation of privacy? And of course the importance of having a proper and available policy on this. Finally, the Computer Misuse Act. I haven't covered it, but essentially if you want to tap your employees' phones, you might go to jail. The last few cases are just about covert surveillance. In all three cases, the EAT and above said actually on the facts of those cases, covert surveillance was justified. They were all employees who'd either been stealing, pretending to be at work when they weren't, while Article 8 is a factor to be taken into account in 98.4, it doesn't displace 98.4. And I put the details of those in the handout. Finally, outside interests, as I've put it, of employees. This was a probation officer who he was the exemplary employee at work, no complaints about his performance at work, no suggestion that he's carried out a disciplinary effect, but he did spend his weekends performing in, I think they were called sadomasochistic clubs. So he was dismissed on SOSR grounds on the basis as incompatible with his work as a probation officer specialising in working with sex offenders. He said this isn't fair and it's contrary to Article 8. Unfortunately for him, none of the ET or the EAT or even the ECHR agreed with him. They said that Article 8 probably was engaged because although these were public performances, they were probably only attended by self-selecting groups of like-minded people. But the interference pursued a legitimate aim, namely protection of the employer's reputation. He worked closely with convicted sex offenders who'd been released from prison to ensure they didn't re-offend, and in such it was important they maintain the respect of the offenders placed under their supervision and the confidence of the public the confidence of the public. So whilst pretty harsh on Mr. Pay, he was doing nothing illegal, he did lose his job and the ECHR did not disagree. I'm sorry I've gone